Good evening and welcome to Arizona Horizon. I'm Ted Simons. A judge today rejected efforts to keep Proposition 140 off the ballot. Now, Prop 140 calls for an end to partisan primaries in Arizona. Opponents claim that 37,000 signatures to put the measure on the ballot were double counted. But the judge today ruled against that challenge. And joining us now is Chuck Coughlin of High Ground, which is leading the campaign for Prop 140. Chuck, good to have you here. Thank you so much for joining us. Real quickly, Prop 140 does what?
Opens primaries. Creates a nonpartisan open primary. It treats every voter and every candidate equally. Signature requirements to get on the ballot, and allows voters to vote for whomever they want.
All right. So that's what we're dealing with here. Yeah. What did the judge rule today? Because you got the requisite signatures. You were going to be on the ballot. Then you were. What happened?
Well, it was a big day. There were three essential rulings that came down from the court today. The first of which, we were challenged that we had duplicate signatures, that we had 38,000 or so duplicate signatures. The way to get on the ballot in Arizona is you have a random sample of all the signatures that you submit, and those are tested by 5% of those are sent to the county recorders. County recorders go through all of them, and they determine a validation rate. You take that validation rate, you pop it off the larger number of signatures. You either make it or you don't. And that's the way the law says that you get on the ballot in Arizona. Our opponents said, whoa, they got a bunch of duplicate signatures in here. And we said, well, those would have been caught in the random sample analysis. We had our mathematician, Mike O'Neill, who's been on your program, PhD, smart guy, show the math that says they would have lost 9,000 of those duplicates because they would have been eliminated in the random sample. The judge concluded that is exactly right, and they were trying to double count all of those negative signatures. Unconstitutional to force us to count double because that would increase the number of signatures that we needed to get. Number two, he said that the mootness of this. So the Supreme Court last week opened the door after ballot printing to continue this challenge. And we said, you can't do that. And we asked to argue that. The Supreme Court said, go argue that in front of Judge Moskowitz. And Judge Moskowitz said, yeah, that's 80 years of precedent. That's what the rule has been. And to change that would permit an open-ended challenge to anything that was on the ballot all the way through the election. That doesn't make sense. Moskowitz says that doesn't make sense either. Finally, he said the remedy that they sought, they sought a remedy that ordered him to tell the Secretary of State not to count our votes because we're on the ballot. Right. We're being printed. And Judge Moskowitz ruled, I can't do that. It's not in the law anywhere. So the Secretary of State filed an argument with us, said that is not a remedy permitted by law. He agreed with that today.
Okay, so basically the Supreme Court said, Judge, these people, they appealed and they said they're not taking this duplicate signature thing, looking at it the right way. The trial court judge did not. So the Supreme Court says, okay, Judge, take a look at it. That's what happened. And today the judge said, I did take a look at it. It's on the ballot, and please don't ask me to say you can't count the ballots because I can't do that. Is that basically what happened here?
That's basically what he said. What they were asking him to do was unconstitutional on two counts and illegal on another count.
Was this... now, I have to think that's going to be appealed, is it not?
Yes, there's an expedited appeal process, which our opponents have already instigated as of this morning. But I can't imagine an environment where the court would take this. Their previous decision was rather Solomon-like in the sense of they kept their hands clean. They told the trial court judge, if you find this exhibit it proves they don't have enough, you order the secretary to not count the ballots. He can't do that. And so he's concluded this. I can't imagine. They have to listen to it. They have to hear something. But do they order briefs or they just say, we're done? I mean, the ballots are being printed. Right. They're being mailed to overseas voters as we speak.
Yes.
And so there has to be a bright line here.
Well, and that's what I'm going to ask, because it sounds to me that if the court, whether it's the Supreme Court or the trial court judge, basically says, you got something here, and I could bring any proposition that I don't like at the last second and tie it up in the courts to where it becomes, you can vote for it, but it won't count?
That's a strategy. I mean, that is clearly a legal strategy by opponents of initiatives of these types of measures to continue to sue, to litigate, and to drain us of cash. I'm confident our committee has already spent or will have spent over $500,000 just defending this. That's a deleterious impact on me, obviously, on the campaign. Additionally, the cloud of uncertainty that casts over the initiative, I have all my donors calling me saying, hey, let me know when that goes. And I'm like, early ballots drop in 21 days. I got to have a campaign. I got to have a campaign going up and positive by the 30th of September at the latest, because early ballots drop, and I have to have that funded. And so I've gone through a lot of conversations over the last week with our donor group, with our creative group about what the hell are we doing here?
Yeah.
How do we do this?
And that again is in regards to the campaign. But what
Yeah.
I'm saying is you could just basically shut down anything by bringing the challenge so late that it gets tied up in the courts.
Right.
And it either doesn't make the ballot
Right.
or it makes the ballot and the court says, well, you can vote on it if you want, but we're not going to count it.
Well, that was the bright line test. That was the 80 years of precedent that the court had established up until a week ago Friday, when they said, okay, continue to hear this. Because the bright line test throughout all of Arizona law was, once the ballots are printed, we're done. We
Yeah.
can't interfere with this anymore.
And as far as the campaign is concerned, I guess what, you rev it back up? I mean, you have to go in overdrive now. You just said you had how much money you spent just fighting this thing.
God bless. I'm Irish. I'm optimistic despite my Irishness. We've been going hard anyways. I was prepared for this eventually. I was confident we were going to succeed. Our lawyers are the best. I was confident in their ability. We are prepared. We have raised money. I'm looking to raise additional money to augment that budget so we can augment the television, the radio, the TV, the billboards, all the things we need to do to communicate with Arizona voters about what Prop 140 does, which essentially treats every voter equally. You know, the essence of justice, there is no justice, period, unless everybody's treated equally. That's what this does.
Proposition 140, the Make Elections Fair Act. Chuck Coughlin from High Ground. Busy day for you?
Yeah.
I should say.
It's been an entertainingly busy day.
Thank you for making time for us. We
Thanks,
appreciate it.
Ted. I appreciate the opportunity.